Hello everyone. In this video, I'll be sharing with you 15 landmark judgments which are given by Supreme Court. These judgments I have taken from years 2016, 2017 and 2018. I have tried to cover judgments from the main subjects of judiciary. If you like my video, please subscribe to channel Studease. You can also click on bell icon for getting a notification regarding new videos. Now I begin with the first case, that is Amardeep Singh versus Harveen Kaur. It was given by Supreme Court in the year 2017. This case relates to the Hindu Marriage Act 1955. Section 13B, which provides for divorce by mutual consent. It laid down that the provision of Section 13B subsection 2 is not mandatory but it is decisive. Second judgment, it is K.S.Puttaswamy versus Union of India. This judgment was given in year 2017. It relates to Article 21 of the Constitution. It was laid down that right to privacy is a part of Article 21. Now moving on to the judgment number 3. Shafin Jahan versus Ashokan K.M. 2018. It relates to Article 25 of the Constitution. It laid down that right to change of faith is fundamental right of choice. Now, fourth. It was one of the major landmark judgments as Section 377 was the most controversial section. Navtej Singh Johar versus Union of India. Section 377 of IPC was partially struck down. It was held that it is unconstitutional, but it has not been entirely struck down. It still covers bestiality and non-consensual intercourse. Fifth, Independent Thought versus Union of India. It was given in year 2017. It relates to Section 375 of Indian Penal Code, which provides that Exception 2 to Section 375 will now be read as sexual intercourse with a wife not below 18 years is not a rape. Moving on to next judgment, Joseph Shine versus Union of India, 2018. Section 497 of Indian Penal Code. It laid down that adultery is no more an offence under IPC, but it is still considered as a ground of divorce under Hindu Marriage Act of 1955. Now, seventh, Common Cause Registered Society versus Union of India, 2018. It relates to Article 21 of the Constitution. It laid down that right to die with dignity is a fundamental right. It said that passive euthanasia as well as living will is still considered legally valid. The word here uses passive euthanasia. It does not legalize active euthanasia. The most important judgment on passive euthanasia is Aruna Schonberg versus Union of India. Now, Union of India versus Mohit Mineral Private Limited, 2018. This case laid down the constitutional validity of GST Compensation to States Act 2017. Now, ninth judgment, Baba Saheb Maruti versus State of Maharashtra, 2018. It is based upon Article 136 of the Constitution, where there is a special leave petition against a death sentence, then such SLP against death sentence shall not be dismissed without giving reasons. The word here uses shall. The court cannot dismiss SLP without giving reasons. It must be a standing order. Now, 10th. State of Kerala versus Rashid. It is based upon Section 231 subsection 2 of CRPC. It laid down the directions issued on examination of witnesses in criminal trial. Moving on to 11th judgment, Narendra versus K. Meena, 2016. It is based on Section 13 subsection 1 of HMA 1955. Section 13 subsection 1 provides for the grounds of divorce to husband or wife, whoever is guilty party. Forcing husband to get separated from his parents will amount to cruelty. Now, if the wife is forcing her husband to get separated from his parents, then it will amount to cruelty, and husband can file a divorce petition under Section 13 subsection 1 on the basis of ground of cruelty. 12th, Subramanian Swamy versus Union of India. It is based on Section 499 of IPC. It laid down that Section 499 is constitutionally valid. Now 13th, National Lawyers Campaign for Judicial Transparency versus Union of India 2017. It is based upon Indian Evidence Act 1872 Section 3, which defines the word document. It laid down that WhatsApp conversation cannot be considered as a document under Indian Evidence Act 1872. Now moving on to 14th, Muthu Ramalingam versus State 2016 laid down that multiple life sentences will run concurrently. Remission of one will not affect the other. Now 15th, Social Action Forum for Manav Adhikar versus Union of India 2018. It is based on Section 498 of IPC. It modified much controversial directions that were issued by Supreme Court in Rajesh Sharma case in 2017. Now, it was held in Rajesh Sharma case that court can be given power that court could give directions to District Legal Services Authority to constitute family committee and also prescribe their duties. Now after 2018, there can be no compromise under Section 498A. Thank you.